Good morning, everyone. I'd like to welcome you to the TIAA Bank Stadium. My name's Whitney Meyer. I'm the Senior Vice President and Chief Community Impact Officer for the Jaguars. And let me tell you, anytime we're able to bring people to the stadium, it's a good time, good energy, good buzz. And we're very honored to host this very important session today. Because for us, the Jaguars, for those of you all who do not know, we actually have a social justice initiative called Inspire Change, and that's led by our wonderful Vice President of Social Responsibility, Tanisha Tate. And we focus on 4 areas. Get a wave in. We focus in 4 areas in that: education, economic advancement, criminal justice reform, and police community relations. So the criminal justice reform, we're really excited to really dive deep and discuss that today. So welcome.
Thank you, Whitney, and thank you, Jaguars, for hosting this event for us today. We appreciate your leadership in being champions of criminal justice reform in the city and nationally through your partnership with the NFL. Our program today includes presentations from 2 panelists: Attorney Charlie Cofer, our community's public defender. That is, his real title is Public Defender of the Fourth Judicial Circuit. It includes Clay, Duval, and Nassau counties. We also have joining him today Ms. Adrienne Johnson. She is the Regional Director for the Bail Project that you'll hear more about. Their bios are on your table. After Attorney Cofer and Ms. Johnson's brief presentations, we're going to have prepared questions, and following that, we'll have questions from the audience. But first, let me offer just a little background. The Community Foundation has been on an equity journey for some time, and throughout this journey, we've promised to listen when appropriate, and when appropriate, to act. One facet of our learning has been around structural racism in the criminal justice system. We studied local practices and conducted several stakeholder interviews, including interviews with our state attorney, our public defender, our sheriff, and the chief judge of the circuit. We learned from these discussions that the bail bond system represented a significant opportunity for reform, one that had champions on both sides of the aisle and had proved to be bipartisan in nature, and that if that reform was successful, it would enable ordinary citizens to continue being productive while they waited for their court date, and it could save the city of Jacksonville between $9 and $12 million annually that is currently being spent on housing pretrial detainees. We were introduced to a national model that had had significant success in other communities. The Bail Project uses what they call community release and support to provide free bail assistance to low-income individuals who are legally presumed innocent and whom a judge has determined is eligible for release before trial. We invited a representative of the Bail Project to make a presentation, I should say, to our board so that we could learn more. After subsequent conversations with the Bail Project and discussions with a number of local members of our legal community, and after doing our due diligence, the Community Foundation committed $150,000 of our discretionary grant-making dollars, $50,000 a year for 3 years, to support this effort. Our support of the Bail Project will go to the wraparound services that the Bail Project provides, not the actual bail. Transportation assistance, child care, reminders to appear, and other support strategies would be the main use of these funds. In addition, we are committed to raising additional funding needed to enable the Bail Project to open and continue to have an office here in Jacksonville. This investment in the Bail Project makes sense to us as community stewards. It reinforces our American, and when I say our American, our community's value that one is presumed innocent until found guilty. It supports those who are least able to navigate the legal system, and it has the potential to free up precious resources that can be redirected to other crime-reducing efforts. We're thankful for our public defender, Charlie Cofer, for embracing this initiative and for championing it with the legal community and providing space in his office for the bail project staff. It is my pleasure. Before I say that, let me also add, I'd like to thank all of you for your support of the Community Foundation and for particularly your support of this project. It's my pleasure now. Well, I think we're going to eat first, and then the program is going to be turned over to Charlie Cofer, who will introduce the criminal justice system and set the context for our discussion today. Thank you.
I'm Charlie Cofer, and I'm the public defender for the Fourth Judicial Circuit of Florida. And I want to thank Judge Davis for inviting us and the Bail Project here to talk with you. What I want to try to do initially this morning is to give you an overview of the criminal justice system, what happens to people who are brought into the criminal justice system. It's only by understanding that structure that you will be able to understand the need for supporting the Bail Project. So, I will assume that in this group, very few of you have gone through the process of being arrested and taken down to the jail and going to court. So for some of you who may have helped people who've gone through that experience, you probably know a good bit about what I'm going to be talking about. But for those of you who have not been down there, who only have viewed the criminal justice system from what you see and hear in the media, it's very important to understand the real aspects of what happens to someone when they're arrested. So what I want to do is to talk about how cases course through the criminal justice system and what happens to the people who are involved in the criminal justice system. There are a lot of ways that people come into the criminal justice system, but the vast majority of them, and the ones that we're here to talk about today, are those who have been arrested. Now, under the law, when a person is arrested, they are entitled to what's called a first appearance hearing within 24 hours of their arrest. Locally, in order to comply with that, our court system has a dedicated courtroom in the jail which provides first appearance hearings. And they do 2 sessions a day so that nobody winds up being in jail more than 24 hours. They have a morning session, afternoon session, 7 days a week, 365 days a year. It goes on and on and on. In my 17 and a half years as a county court judge, I've probably presided at over 700 sessions of first appearance court. And that's a lot of sessions and a lot of people. So, they go to first appearance court within 24 hours. When somebody comes into first appearance court, they sit out in the audience there, and they are shown a 12.5-minute video, which explains all of their constitutional rights and explains what is going to happen during court when the judge comes out. You have 2 types of cases primarily, felony cases and misdemeanor cases. If a person's in there on a felony case, it's a fairly limited hearing. The judge cannot resolve that case. What happens is the judge determines whether there's probable cause in the arrest paperwork. They look at the person's record, the seriousness of the offense. They may or may not set a bond on that particular defendant. They usually will appoint the public defender's office to represent them unless a private attorney has come in or the defendant indicates that they have the means to hire their own attorney. And then finally, they set a bond in most cases and pass the cases usually about 10 days potentially for arraignment. So that's felony cases. The cases we will probably be focusing on mostly here today are the misdemeanor cases. When a person's charged with a misdemeanor, there's a little bit difference. A county court judge or a presiding judge at first appearance hearing can come in and actually resolve that case at first appearance hearing. And because of the number of cases coming through that court on a daily basis, there's a good deal of pressure to try to resolve as many of those misdemeanors as possible. We're going to come back to that thought a little bit later. So if a person enters a plea at first appearance court and are sentenced, that case is done with. If they do not enter a plea, typically what will be done is a bond will be set on their case. In many cases, my office will be appointed to represent them. And their case will be passed anywhere from 7 days to up to 3 to 4 weeks to when that judge is back in their regular criminal courtroom. All right, so court's done. At that point, the person, if they've not resolved their case, knows what their next court date is, knows what their bond is. So they have the option, a couple of options on posting that bond. If they have friends, family who have the means to post that bond in cash, their family and friends or bosses can come down with the total amount of the bond, let's say it's $1,503, and post that bond with the jail, and they'll be released. If the charges are dropped or they are acquitted, that bond money is returned to whoever posts it. If they are convicted, the court has the option of taking fines and costs out of that bond money, and the balance is returned. So that's option one. The second option is if they don't have family or friends who have sufficient funds to post the bond, they can go through a bondsman, a surety bond. And what the bondsman will do is charge that family, friends, or defendant a 10% fee, 10% of the bond as their fee for posting a surety bond. And if a surety bond is posted, then they're released. All right? So those are the two ways. If they don't have family, friends with the means to post a cash bond, or don't have the means, either through family, friends, or themselves, to post a surety bond, they remain in jail. All right. So after the posting of bond situation, what occurs between first appearance and their next court date? Basically, the state attorney's office will be reviewing their charges. My office will be trying to do what we can do to represent them. There are a lot of options that happen at that point. The state can file felony charges. The state might choose to drop the charges down to a misdemeanor and their case will be rescheduled. The state may choose to drop the charges. Or they may refer the case to one of many diversionary programs that the state attorney's office has, either pretrial intervention, veterans treatment court, drug court, mental health court. All of these decisions take time. In many circumstances, the decision to file formal charges or to divert a case take a lot more time on felony cases than that initial 10 days, and the state has the option to keep pushing the cases off. On felony cases, generally, that filing decision is made anywhere from 50 to 40 days after the arrest. On misdemeanor cases, typically after first appearance court, the next court date in front of that judge will be 7 to 28 days after the arrest. Long term, we have speedy trial rules that require that the case, unless speedy trial is waived, our felony cases are supposed to typically be resolved within 175 days, misdemeanors within 90 days. Now understand all these time periods that we're talking about. If a person posts bond or cash bail, they're out. If they don't, they're sitting in the jail. So let's get some comparative statistics of where Duval County stands in terms of jail and prison incarceration. We have here the U.S. average of some counties that are similar in our size. I think you see that our rates of incarceration far exceed what the national average is or what counties of our size are. Duval County incarcerates people at the rate of about 1.5 times that of the Florida incarceration rate and about 2.5 times the national incarceration rate. On average, any given day, there's 2,800 people within our county court jail system. That's the Duval County Jail, Community Corrections Division, Montgomery Correctional Institution. If you see there, these statistics come from 2015. There's not been an updated study. We've had COVID, and so we're still recovering from that, so it's not a good time to do additional studies. But I would suggest that these figures are pretty steady. Things have not changed a lot from 2015. In that year, over 30,000 people were admitted to the jail. Bail was set on 24,000 of them, and 14,000 people remained in jail for the duration of their case. People sentenced in Duval County make up 8% of all inmates incarcerated in Florida prisons, but Duval County is just 4% of Florida's population. So, the main findings of this study that was done in 2015 show that people are rarely released from the jail on offenses on their own recognizance, meaning without having to post bail or a bond. And that releases on own recognizance are rare even when there's been a bond review, maybe a week, 2 weeks after an arrest. And so even relatively low amounts of bail keep people in the jail. So on trespass, the study showed that 1,500 people were booked with trespass as their top charge during that year. The median bail amount was set was $2,508. 27% of the people were able to be released on an ROR. 68% did not post bond and remained in jail till their case was resolved. Petty theft, similar numbers. 665 people were booked. Median bail was $2,503. 6% of the people were released on their own recognizance. 83% of people did not post bond. The figures continue on charges like suspended driver's license, first time driving on suspended license. 54% of the people did not post bond. Simple drug possession, this could be less than 20 grams of marijuana. Median bail was $3,000. 71% of the people did not post bond. Felony amounts, ironically, a higher percentage of them posted bond than for the misdemeanors. I don't make the figures up, those are the figures. So this is a figure I want you all to really look at, and we're going to come back to it. During 2015, 2,513 people pled to misdemeanors within 2 days of being booked into jail, meaning 2,500 individuals entered a plea of guilty or no contest to resolve their charge at first appearance court. We're going to get back to the why does that happen. 321 people pled to misdemeanors after spending anywhere from 3 to 14 days in jail. This is an additional group who probably came back to court at the judge's next court week and resolved their cases 4 times served. The median bail set on a misdemeanor is $2,508. This shows the general time to disposition on misdemeanors. You see the number of misdemeanors resolved at day 1, meaning first appearance court. And this is the distribution on felony cases. Let me back up before I show you all this slide. Let me ask a poll of you. Who knows which county in this state has more people in state prison than any other county? Here's the answer. Duval, when I took office, I ran across this figure, and every year I do an exercise of figuring out how many people are in state prison system out of the various counties. And every year, Duval County has more people in state prison than any other county. We have right at 1,000 people more in state prison as of last month than Miami-Dade County, which has right at 3 times our population. There is an aspect to the inability to post bond and get released, which adds to this figure. So, what we're going to be able to be focusing on today are the people who are unable to post bail. Adrienne?
Thank you, Charlie. So when I'm not an attorney, I am a volleyball coach, so if you can't hear me, I certainly can shout. I want to give some life to some of the numbers that Charlie was talking about. On the 3rd day that I was a public defender, I represented a man who had been stopped by police for jaywalking. And after his interaction with the police officers, he was arrested because they suspected that he had been disorderly at a nearby bar. He and his wife lived at an extended stay motel across the street from a bar. And I remember distinctly going to his bail hearing. And I went to the back of the courtroom before the hearing started, and I asked his wife if she could afford to pay anything to bail him out of jail. And so she opened this big giant bag and she started digging through and she pulled out all the cash that she had. It was $87. And so I was in the position of having to go argue for a bail that was less than the $87 that this woman had with her. And I was able to do that. I was able to get a $50 bail, but then what I was left with was whether she could pay for the next night in her hotel room, what she and her husband were going to eat that night, whether she could pay for their bus pass to get to work, whether she could pay their phone bill. And so that was my introduction to bail on my 3rd day of work as a very excited, very eager public defender. And what I learned over the next 8 years is that that client was not an anomaly. That was a story I heard and saw over and over and over again. One of the most basic promises of our criminal legal system is that we all have access to equal justice under the law, and that we are all promised that we are presumed innocent until we are proven guilty. And the challenge with the way that the cash bail system currently operates is that it creates a 2-tiered system of justice where some of us who don't have financial resources access the justice system in a different way than folks who do. So I want to share with you some quick facts about bail. On any given night in this country, there are about 500,000 people sitting in a jail cell pre-trial, presumed innocent, simply because they cannot afford to pay. In fact, cash bail has been the single largest driver of jail growth over the last couple of decades. It accounts for 100% of the jail growth. And what we know is that that disproportionately affects communities of color, and lately, it disproportionately affects women, who are the fastest growing group of folks who are incarcerated, and that those folks are subjected to the harms of jails almost immediately once they get there. So in 2017, the Bail Project set out to do something about this. We hear every day from community members and families and service providers and public defenders that there is a need in their communities for folks who need financial help. And so we are showing up to be responsive to the need that the community has identified. So in just 5 years, we've been able to open more than 24 sites across this country. We've paid more than $70 million in bail. We have prevented more than 1 million days of incarceration. And ultimately, what that has done is saved communities like this one more than $80 million in associated costs of pretrial detention. But providing the bail assistance for low-income individuals is just part of what we do. It's how we respond to immediate needs, but that really isn't our strategy. Our strategy instead is to build a body of evidence that we can reimagine the way that the pretrial system works, that it can work differently. And we've done that by posting bail for almost 27,000 people across this country. And what we found is that overwhelmingly, folks return to court because of meaningful support in their communities rather than simply having $500 on the line, or $50 in the case of my client. And so we're building a body of evidence to show that there are alternative ways to invest in a pretrial system that is just and equitable and safe. So one of the things I get asked a lot is how we make these decisions. How do we decide who we're going to help? And one of the first things that we consider is a person's financial need. The other things that we think about are their bail amount. The average bail that we pay is, at or around $5,000. Here in Duval, you saw Charlie say that the average bail set for misdemeanors is about $2,500. And then we partner with community organizations who will support folks once they're released, help eliminate the obstacles to returning to court, like Operation New Hope has been a partner here. We help provide assistance like transportation and court reminders. I always joke, I get a text message every time I make a dentist appointment that I need to go to the dentist. And something as simple as that helps folks return to court. We call our model community release with support. And what we do is we interview folks to help determine their eligibility and then connect them to the things that they need to get back to court. Because after all, that's what bail is for. Bail is meant not as a punishment, but only to ensure that a person returns to court. So we help to ensure that they have the things in place around them that they need to return to court. And after 5 years, we've noticed some really meaningful trends. Almost 2/3 of the clients that we support are from communities of color. Almost 1/4 of the folks that we help report having some substance use history. About 17% of the folks that we support have mental health needs. And so our model really is what we call a revolving bail fund. So once you post a full cash bail, most people don't know this, but once you post a full cash bail, once the case is resolved, that money comes right back to you. So we use the money we post for John Smith, and once John Smith resolves his case, we take that very same money and use it to post for Jane Doe. And like I said, we've posted over $70 million in bail assistance, and we've bailed out, that number's a little higher now, almost 27,000 people. Folks have returned to 72,000 court dates and have a court appearance rate of 92%, with no money on the line, no financial obligation to the court, and no financial obligation to us. We connect them with community services. What we found is our clients, usually the most requested service is mental health needs. And we see that case outcomes are more fair. Almost 1/3 of our clients ultimately have their cases dismissed. 92% of the money that we posted, of that $73 million, has revolved to help another person. Here in Jacksonville, in Duval County, what we are seeing is that there are, of all the folks in the jail, most of those people are being held pretrial, meaning they've not been convicted of a thing and they're not serving a sentence. Almost half of those who are being held pretrial won't be released until their cases end. So, what impact can an organization like the Bail Project, but really, what impact can reimagining the pretrial system mean for Duval County? And what it can mean is something as simple as reducing the pretrial population here from 2,100 people to 1,700 people could save millions of dollars just by reducing 300 people a year. But the Bail Project and other bail funds, we're not the only bail fund that exists. We're a powerful tool and an immediate release valve for folks who have an immediate need. But the truth is, we don't want to be here forever. We want to be able to put ourselves out of business. I would be happy if I did not have this job. And so our goal is really to build a body of evidence to help communities start thinking about other ways that they can support folks, your neighbors, your friends, your family members, folks in this position, to start reimagining a pretrial system that is more just, more equitable, and more fair. Our hope is that by showing up and helping for a few years, we jumpstart you and provide the evidence that you need to carry this torch forward. Thank you so much.
Charlie, share with us, if you will, the real world decisions that the poor have to make at first appearance hearings.
I'm glad you asked that question. The best way I can answer that question is to give you a demonstration of one person's life during that time of their arrest. So think about this individual, Bob Jones. Bob is single, lives in Jacksonville, has no family here. Basically is what's called a day laborer. He gets up in the morning, goes down to Union or State Street and hangs at a corner where people who need day labor come to pick them up, either to help with tree trimming or to dig ditches or to do menial tasks. He's paid in cash at the end of the day. Paid in cash at the end of the day. All right. He doesn't have a house. He doesn't have an apartment. He has a room downtown in the rooming house where he pays rent for a week-to-week basis. So the amount of money that he can earn as a day laborer is just enough to pay for that room on a timely basis so he doesn't get kicked out, and pay for his food and little more. Many of you may have seen people like this because when you have work people come to your homes, there's always the day laborer with them if they're doing heavy labor work. All right, so Bob Jones has had a good day of working, and his room is downtown. He's had maybe an arrest history before. He's walking back to his room, coming down Main Street. Does anyone here own the business at 715 Main Street? Good. Okay. 715 Main Street is our local downtown Shell gasoline station. It's a magnet for homeless and other people. If you've driven down Main Street, you will see it. And from time to time, the owners will call the sheriff's office to come get their lot cleaned out. So Bob's walking home down Main Street, sees some other people he's worked with before, stops to talk with them while he's standing on the sidewalk next to 715 Main Street. Unbeknownst to him that this is a day that the owner has called the sheriff's office to come clean out the lot. Officer comes up to him, maybe the same officer who arrested him 3 months before at the same location, and he says, "You all need to leave." The person says, "I'm just talking with my friends." Case over. We're in the back of a police car, we're charged with trespass. Booked in the jail, come down to the jail, and then taken to first appearance court the next day. All right, this is what some people have called 30-second justice, and I'm going to try to recreate for you what happens. They sit and they listen to the 12.5-minute tape. Eventually their case is called when the judge comes out. The judge says, Mr. Jones, come forward. Mr. Jones, you're here on a charge of trespass at the Shell station. I see you were here 3 months ago. You were sentenced to 5 days. If you'd like to resolve your case today, I'll sentence you to 10 days in the Duval County Jail, give you credit for the 2 days you've already served. Do you want me to appoint a lawyer, or do you wish to represent yourself on the case? At this point, Mr. Jones says, Judge, I was standing on the sidewalk. All right, Mr. Jones, I'm going to appoint the public defender's office. I'm going to set your bond at $1,503. I'm not back in criminal court for 3 weeks, so I'm going to pass your case for 3 weeks from now. Step on in the back. All right? Halfway stepping in the back, Mr. Jones may have the wherewithal at that point said, Judge, I'll take the 10 days. Because he's done the calculation of realizing that he doesn't have money to post bond, he doesn't have friends to post bond, he doesn't have family to post bond. And so he's either going to spend 8 more days in county jail because he can't post bond, or he's going to spend 3 weeks in jail because he can't post bond. Sometimes the judge may call them back up, take the plea, sentence him to 10 days. Other times they say no and move on to the next case. That figure of 2,500 people, that's what that figure represents, the 2,500 people during that year who wound up resolving their case at first appearance court. They didn't really have the opportunity to even have our office pull the body cam video to show where they were at the time of their arrest. He may have had a valid defense, he may not have, but he didn't have the opportunity to do much more other than make the quick decision that out of matter of expediency, it was better accepting the offer made to him than to spend 3 weeks in jail. So that's the real world issue.
Thank you, Charlie. Adrienne, you touched on this a little bit in your presentation, but can you share some of the problems that are faced by individuals who are unable to post their bonds?
Yeah, you know, I always like to invite folks to imagine that they have been arrested and are told that they are eligible to be released only if they pay $2,000. By the way, 1 in 2 Americans can't afford a $1,000 emergency expense. So when you're making that decision and when you're sitting, the first things that probably come to mind is, who do I know with that kind of money? And then it's, who's going to call my boss to tell them that I'm not coming to work tomorrow? And if I can't call my boss to tell them I'm not coming to work tomorrow, will I have a job when I leave here? And if that person is a parent, who's going to pick up my child from school? Where's my child going to go if I stay here? One of the things that we often see with a lot of our clients is, who's going to get my medication if I have mental health needs or physical health needs? What's going to happen if I don't get those things immediately? So those are the kinds of problems that folks who get arrested are evaluating immediately and very quickly once they get arrested. And I want to be clear that that number across this country is 5 million people every year. So 5 million people on their first day in jail are making all of these calculations very, very quickly. Almost all of them don't have access to $2,000, which is the average bail we pay nationally. And so they're making these decisions based on their financial resources rather than on the facts of their case.
Let me ask this question, though, Adrienne, because it hasn't been asked yet, and I believe someone in our audience would likely ask this question, that one of the criticisms often raised against reducing pretrial detention is that it threatens public safety and increases recidivism. Let me hear you and Charlie speak to that, please.
Sure. The fact of the matter is jail destabilizes a person's life. And what research has shown us is that if you compare a person who has spent 1 day in jail to a person who has spent 8 days in jail, the person who spends 8 days in jail is 56% more likely to commit another crime. So it's actually the exact opposite. The research tells us exactly the opposite of what conventional wisdom might tell us. Because being in jail for a week destabilizes your life in so many ways that it makes you more likely to reoffend. So what we're finding is if you are able to quickly intervene, get folks back out, get them the support that they need in the community, they're much more stable and you're much more likely to have a safer community.
Yeah, this isn't just one study. Multiple studies have been done around the country of bail systems and the effect upon individuals and communities about the failure of individuals to post bail, the destruction and damages to their family, loss of income. My particular example, if he stays in a week, the other 8 days, he's likely to have lost that residence and the value of whatever he had paid toward that residence. His belongings. He may be able to get started back up, but he's more than likely to be a patron of the Sulzbacher Center or Trinity Rescue Mission for a long time until he can acquire enough money to pay for another room. If he's one of the individuals we're talking about who has family, he's lost that ability to provide for his family and assist his family, which places a greater demand upon our social services system. Every study I've seen, and I've got a word file of all the different studies, has come to the same conclusions. What many people in the community think would be the result of these reforms is just contrary to what the evidence shows.
Let me drill down a little bit on the misperceptions that exist, and I think this question will help disabuse some of them. When the bail project posts bail, what criteria does it use to determine who to post bail for?
Sure. So, the bail project is not in a position to be a judge. It's not in a position to be a jury. We're not making determinations about who is eligible to be released or about their guilt or innocence. And so we really respect the decisions that local judges make about who might be eligible to be released back into the community. At the point that we intervene, the only thing standing between the individual and being released is money. And so I like to say that we're like a lot of people's grandma, right? We just show up with the cash, but we don't just show up with the cash. We are particularly interested in understanding the broader circumstances of folks' lives. And so what we do is when we get a referral from the community or from the defender's office is we go interview each and every person who is referred to us. And we do that because we aren't using, a matrix that dehumanizes folks. We take folks as they are and we ask them what their needs are, ask them what support they need in the community, evaluate each person as an individual. And so we're taking into consideration who supports them, where they will live, how they will get back to court. And we're developing an individualized release plan for each person that will accommodate their needs. And so what we do and what we think about changes from person to person because that's how we deliver equitable results.
The Bail Project has been doing this long enough that they can gauge criteria which make a particular individual a bad risk for supporting. Because it doesn't help the bail project, doesn't help my office, doesn't help the community if they just willy-nilly post bail for everybody. They have criteria, they have guidelines, and they've been successful. They're constantly refining the guidelines because for them to have long-term sustainability, they have to support people that will be coming back to court until their cases are resolved. So,
I'm going to drill a little further on this same subject. Violent persons accused of violence have bail set for them. Does the bail project post bail for violent offenders?
So I always like to remind folks when I get asked this question, because I get asked this question a lot, bail, the purpose of bail is really just to ensure that a person is coming back to court, right? So again, I don't make decisions about who is eligible for bail. A person has had a hearing that a judge has made a determination after hearing evidence that I was not there for, and in all of his or her wisdom, they have decided that this person is eligible to be released back into the community. So where the bail project comes in when we are considering folks who are accused, not convicted of a charge related to violence, is we consider what supports that person might need. We certainly are considering community safety. We care about community safety. And so we are asking, for instance, if there is a place, a home that the person can go to away from the alleged victim, complaining witness, things like that. So we're thinking about what supports a person might need to return to court, because that's the purpose of bail. It's not our job to make determinations about eligibility for release. That's, judges in all of their wisdom are able to do that in a way that is far better than we are. We are really coordinating release plans and supportive systems around folks.
You touched on this a little bit, Adrienne, in the presentation. Return to it. According to Vera, the number of women in prisons has increased more than sevenfold between 1978 and 2017. And the number of women in Florida's jails has increased more than 14-fold between 1970 and 2015. What criminal justice reforms and community-based interventions would best address the needs of Florida's rising population of incarcerated women?
Yeah, Florida certainly tracks with the national trend that we're seeing that women are being incarcerated. They're the fastest growing group of folks who are incarcerated. And we don't really have great research about why that is, but that doesn't mean that we can ignore the data that it is happening. The interesting thing about incarcerating women is it is particularly disruptive to families when women are incarcerated. The last statistic I saw was that of the women that are incarcerated, 80% of them are mothers. And so we're talking about impacting children. We're also talking about, short stays in a jail disrupting services like Medicare or Medicaid or Social Security or healthcare benefits if they're employed. And so when we think about the growing population of women in jails, we also should think about what very simple interventions can both protect the community, ensure that they're returning to court, but also get back to stabilizing their families. So things that we have done that have been effective are providing cell phones, providing court reminders, providing rides to and from court, helping to coordinate child care assistance. Those simple interventions go a long way in reuniting families and are so much less disruptive of a family unit.
I don't really have an explanation why the proportion of women coming into our system is increasing. And I hate to get off topic here, but I'll go back to one of my common themes when I talk with groups, and that is most people in our community think that the way you deal with a crime is for greater punishments, minimum mandatories, things of that nature, which helps explain, I think, why Duval County has more people in state prison. In my discussions with every sheriff I've ever been involved with, they have an understanding that you can't arrest your way out of a crime problem. Our sheriff's office does a great job of arresting people and prosecuting them. Until the community recognizes that reduction in crime, and that's this for men and women, only results by reducing poverty within our community, and I don't mean giving money away, but increasing job opportunities, increasing support systems so children coming up in homes that are impoverished can have a better chance of success. I think we will continue to be missing the boat. Kevin back there is shaking his head yes. He understands this because he has been targeting Reggie up there, Mandy. They are targeting that intercepting people and getting them out of poverty. That will go a long way toward it, and maintaining support system for women and families.
What does the failure to obtain pretrial release mean for a defendant's case?
Well, I think Adrienne talked about it earlier. I'm having some issues here. Our promise is that a person is innocent until proven guilty. That really is a promise only delivered to people who have the ability to bond out of jail. And it's not for the poor who don't have that ability. There is so much pressure to resolve cases quickly, both on the court's part and on defendants' parts, that a person who may have an absolute defense of the case, just as my example, somebody standing on the sidewalk rather than on the premises of a business, they have an absolute defense to that. An attorney would be able to handle that case simply, but because of the realities of their life and their circumstances, they wind up entering a plea, taking a sentence of 10 days, to avoid what is effectively a sentence of 21 days or more, because that's the structure of the system. So they're waiving their right to counsel, waiving their right to a trial by jury, waiving all of those rights that that 12.5-minute video that they're shown explained to them. But realistically, it boils down to, can I keep my room? Can I convince my landlord to keep my room? I might be able to if I'm only in here for 8 more days because I paid my rent yesterday. Those are the things they sacrifice. All those rights that we are entitled to are placed under threat by their inability to pay bond.
And I'll add, I see a couple of defense attorneys in the audience, and in conversations with them, if you're in jail, you can't help your attorney establish your defense. If I'm accused and I'm in the community able to assist in that research and investigation and witness gathering and the like, it certainly enhances the chances of having your innocence established. Last question, and then we're going to take some from the group assembled here. What reform efforts have you seen and been proven to be most effective generally in criminal justice reform, and which are, in your opinion, the most politically palatable?
This question is interesting because in theory and on paper, we have the tools we need. We have the right to a speedy trial. We have the right to be represented by counsel. We have the right to confront the witnesses against us. The problem really becomes when we infuse the criminal legal system with money. and deliver justice in different ways to folks who have money and don't have it. And so really, when I think about and when I talk about reform, what I'm actually wanting is to get back to the ideals of what we want our justice system to be, the tools that we already have. And so when we think about reform more broadly, I don't think of it necessarily as an overhaul of our justice system, but more of being able to actually use the tools that we have at our disposal, because right now, we're not in a place where we are effectively using those tools.
Yeah, there are great rules in place, and this is kind of getting down into the weeds. The general rule about bond is that there's a presumption that a person should be released on their own recognizance. That's the rule. Now, is there adherence to the rule? And I'll be the first to confess. My 17 years, I did not start out presuming an ROR, a release on recognizance, was appropriate. If you go to court and listen to the conversations, how it's supposed to work is that the judge will look to the state and say, why should I not ROR this person? In reality, if you come listen and watch court, they look at the attorney and ask the attorney to justify why they should be released on their own recognizance. And so some of it's a mindset. Some of it's a mindset that's been ingrained for a long, long time. So the rules are in place there. It's going to be difficult to change that mindset.
It's going to be difficult. This project is one of the tools, I think, that can help move the system and the community to begin to embrace that possibility. I'll give you another example of a rule that's in place. You all are probably, because everyone here has been keeping track of this criminal justice reform arena, the state attorney made some changes in serving juveniles with notices, what do they call it? Civil citations.
Civil citation.
And it resulted in a tremendous decrease in the number of children that were arrested, and some in decreases in juvenile delinquency. So it was a win-win for us and for the state attorney's office. There is in place under Florida law something called a notice to appear that can be used with adult misdemeanor offenders. The police do not have to arrest. They have and can have the discretion to say, well, this is your court case. You need to show up or we're going to come get you. That's not embraced in our community and in the current culture that we have within law enforcement. But it can be. The rules in place.
I think that's a great example of communities' assumptions and presumptions about how the system works, which are just so wrong. I'll have to commend my noble opponent, Melissa Nelson, that the issue of juvenile civil citations was at the forefront of our campaigns in 2016. When she came in, she took the lead, got every sheriff to sign on with it, because the community's thinking was that if officers issued juvenile civil citation, the little rugrats are going to come back into our system, they're going to get out and reoffend, and juvenile crime was going to boost. It didn't happen. It didn't happen. And a lot of people said that it wouldn't happen. The whole concept of bringing juveniles into the system, putting them at the detention center, probably made them more likely to be recidivists. I mean, it's just an incredible thing how people's assumptions about what works and the cause and effect of things in our system sometimes are not accurate.
Charlie and Adrienne, thank you for entertaining my questions. I'm now going to ask any of you that have questions to please pose them.
So, Your Honor, you touched on this a little bit, but I'm curious, at the first appearance, isn't the party charged able to have some sort of legal representation? And if so, is there something missing in the public defender's office's ability to confer with the client? Because it strikes me in your example of the day laborer, if the public defender or somebody from the office had even a little bit of time to find out the person's situation, they would be able to make a compelling case on that person's behalf. I'm missing something here of the role of the public defender's office in the first appearance situation.
My mind always goes back to one Friday afternoon when I was handling first appearance court as a judge, and I had 110 cases to go through in about 3 hours. And what happens in a case like my example, the best way to determine whether the client had a completely defensible case of merely standing on the sidewalk rather than on the premises is to pull body cam video, which is not even downloaded for days, or talking with some of the other defendants who might be in court that day. It is a limited hearing. It's not a hearing over guilt and innocence at first appearance court. It's a question of whether there's probable cause, and usually the arrest narrative set forth probable cause, and an opportunity to have an attorney. The difference is it's really not possible to do an effective job in that setting in that 30 seconds until the next case is called. Now, if our client is out and we have come in, we might be able to pull cameras that are along Main Street to show where he was at the time, the body camera footage. During those 2 weeks that he might, 2 or 3 weeks where he might otherwise be in jail, we could do our work. So it's the practicalities of the situation.
So if we all agree with the premise that the poor are not going to get the same justice as those with means, I mean, this bail project a lot of sense as a first step. Is the other big, is there another big piece out there that, so you get off on bail, but, and maybe it's hard to ask, for you to answer this question, but I hear that there are in a lot of major big cities, public defenders' offices can be very overloaded. Maybe they don't have the funds. I mean, I'm just presuming that if I was charged with something versus, anybody in this room versus somebody with no money, anyway, is the other piece of this too, and do you also help advocate through private attorneys to help people with their case once they're out, or is it just the bail piece? Does that make sense? Or?
Yeah, they're public defender systems, I think uniformly around the country, are underfunded and understaffed. I will say our situation in Florida, we were, I think, the first state to develop a public defender system, is probably leap years ahead of some other states. For example, Louisiana, which is just incredibly difficult. Could we use more? No, but yes, we could. Ms. Nelson has half as many attorneys as we do and twice the budget for salary and benefits. We have made progress over the last few years. There's certain things that my office, I think, we take great pride in that we do very well. Handling homicide cases. I think most people who are in the criminal justice system realize that if you're charged with a homicide, you're better off with my office than with most private attorneys, just because we've had the experience. That is at this point, yeah, could we use more people? Yes. But I think right now our office is doing the best it has in a long time. I know that, I just take great pride in it, which is why I came back to the office.
And thank you, Adrienne, both for sharing your experience and knowledge about this subject. And thank all of you for your questions and for the attention you've given while we're here. And our hope and prayer is that you'll continue to give attention to it. With that, Tom, I'll ask you to close it.
Yeah, thank you. So first and foremost, I apologize for anyone whose questions we didn't get to. If you have a question, see me immediately after, or you can email it to me. I have had the pleasure of getting to know these email addresses by heart, so I can certainly coordinate to get a response to your question for the benefit of the whole group. So again, if you have a question or if you generate one on your ride home, please send that to me. From the Bail Project also provided more perspective and context on a national scale, and I could not be more excited to know that the Bail Project has now been 9 months. At your place settings, you have both a brief bio of the two incredible speakers. On the back is the now infamous, we did not copyright this, so you are welcome to use it and share it with your friends, Charlie and Tom's flowchart. And then the Bail Project, this is an impact story now that they have boots on the ground here in Jacksonville. So I encourage you to read this when you are not operating a motorized vehicle. But maybe before you go to bed tonight, if that's my commitment of you to make, is make sure you review this before the end of the day. My last privilege of the day is to give you a sneak peek into the Donors Forum topics for the spring of 2023. In February, we are going to be focusing on the refugee resettlement efforts across the First Coast and multiple refugees who are coming in from various parts of the world, and we're going to talk more in First Coast. In March, we are bringing Coventry Edwards Pitt. She is a national author. She has been here in 2017. She's produced 2 previous books called Raised Healthy, Wealthy, and Wise, which spoke about raising children within families of wealth, and then she covered Aging Healthy, Wealthy, and Wise. And her newest book is the 3rd milestone, which is Engaged, Healthy, Wealthy, and Wise. She's going to speak across all 3 of those life experiences, but we're excited to host her in March. And then lastly, in honor of Mental Health Awareness Month, we will be revisiting the topic of mental health support services across Northeast Florida. Dates are coming. I'm working feverishly with some local speakers to build this out, but these are just a glimpse at the topics that will be coming. With that, I want to thank you all, you're my finalists of gratitude, for attending. If this is your first Donors Forum, welcome. Please come back. If this is your second or third, or if you managed to get the punch card to all 6 of these, thank you for being our loyal supporters of this program. It is an honor for me to curate this, and I welcome any ideas or feedback that you have as we move forward. Have a wonderful holiday season, and safe travels.